Kumar, are you there? I just let you in. I didn't even know I was that powerful. Right. But I'm not hearing him. Huh?
We can see you, but you might want to say something. Just make sure I can hear you.
Yeah, can you hear me now? I turned on my microphone.
Yeah?
We can. All right. So we can hear you and we can see you. All right.
Great. Okay. It's with WebEx, I always have to reinitiate my camera and microphone.
Okay. All right. So we're on the record in Public Service Commission Public Conference 65, Senate Bill 1, accounts receivable related to residential electric and gas supply. So why don't we start with taking appearances? And I guess that mic.
Good afternoon, Chair Hoover.
Yeah, I think you hit the button. Make sure we're on.
Good afternoon, Chair Hoover, Commissioners. Lloyd Spivak for the Commission staff. Ruthie Herman is with me, and Dave Hoppick is available on the screen as well.
Good afternoon. Good afternoon, Mr. Chairman, Commissioners. Jacob Auslander on behalf of the Maryland Office of People's Counsel.
Good afternoon, Mr.
Hey,
Chairman.
Mr. Chairman, this isn't the most. Mr. Chairman?
Yeah, go ahead.
Yeah, this isn't the most important thing in the world, but the camera is very blurry. If somebody could sharpen the focus, at least that's the way it is for me. But it's not, if there's nothing to be done, then that's that.
Yeah. All right, we're going to try, so no promises. So.
Yeah.
Yeah, that one.
Well, if it is what it is, as long as I can hear people, that's the important thing.
All right. Okay.
Good afternoon, Mr. Chairman and Commissioners. Matthew Seegers, appearing for Pepco and Delmarva Power.
Good afternoon, Chairman Hoover and Commissioners. It's Laurel Peltier from Maryland Energy Advocates Coalition.
Good afternoon, Commissioners. Beverly Sikora on behalf of Baltimore Gas and Electric Company.
I couldn't hear who that was.
Okay.
Was that Miss Sikora?
Yeah.
Okay. Then I'm good.
Good afternoon, Jessica Reba on behalf of Potomac Edison.
Good afternoon, Damon Krieger on behalf of Southern Maryland Electric Cooperative.
Good afternoon, Spencer Nichols on behalf of Washington Gas.
Good afternoon, Brian Green on behalf of the Retail Energy Supply Association, NRG, and Clean Choice.
Good afternoon, Stacy Rantella on behalf of SFE Energy.
Mr. Chair, if folks could actually use the mic in the middle, I think that actually works better.
All right. So is that everybody that wants? Okay. All right. So we had asked for comments on this particular section of SB1, and I think what I'm going to do is start with the utilities, and then move to the retail supplier entities, and then other entities beyond that, and end up with OPC and staff. So Mr. Seegers, you want to start? Yeah, although you may have to move around just so I can get the right mic, so to speak. So.
First, I just want to check, are Commissioners Barvey and Suchman able to hear me okay?
Yes, I could actually hear you well.
Okay, great.
Yeah, me too. Me too.
All right, so this this might be the mic. So if we have to shift around chairs, we'll be fine.
That's fine. Once again, good afternoon, Mr. Chairman and Commissioners. Matthew Segers, S-E-G-E-R-S, starting off for speaking on behalf of the Joint Utilities. Appreciate this opportunity to provide our comments. First of all, as we discussed in our comments, we wanted to notify the Commission that we seriously question our practical ability to shift from purchase of receivables to another form of customer payment allocation by January the 1st of 2025, just given the significant amount of IT system and other process changes that will be necessary, as well as the unresolved legal issues. However, okay, don't know what I did, but I will try not to do it again. However, to address the specific issue,
Mr. Seegers, we lost you.
Yeah, I can't hear you.
Turn it back on.
Can you hear me now?
Better.
Okay.
Yes.
My apologies. However, to address the specific issue of today, the Joint Utilities do believe that the Commission can unilaterally modify purchase of receivables to prohibit the purchase of receivables for all residential customer contracts. The first thing to remember is that the purchase of receivables is purely a creature of the Commission's creation. It is not enshrined in statute. There is no statutory language or provision that guarantees that purchase of receivables will be an option in perpetuity. In addition, as it stands right now, and as we noted in our comments, COMAR, specifically Section 2053-0506B, it permits the utilities to stop purchasing receivables for utility consolidated billing at any time. So therefore, the use of purchase of receivables was always, there was always the possibility that it could be changed by this Commission. Now, RISA and other suppliers, they claim in their comments that they have a contractual right to purchase of receivables, and that SB1 should be interpreted to safeguard this contractual right. But first of all, as this Commission itself observed in its notice,
Lost him again.
Can folks hear me okay?
Well, we
Now.
lost you, but now I can hear you again.
Okay, my
Yeah.
apologies. We're having some feedback issues in the hearing room.
Yeah, it's kind of what the. We turn off the other mics, or yeah, turn those off.
I think these are all off. I'm trying to go as quickly as I can. Okay. Just let me know when you're ready for me to restart. No worries. I can try and keep going and see if it.
Well, the only thing, I mean, interrupt your flow, like not really fair to you.
I've dealt with worse. I can try and keep going and see if it continues. Okay. Now, as I said before, RISA and the other suppliers, they claim that they have a contractual right to purchase of receivables, and that SB1 should be interpreted to safeguard that contractual right. But first of all, as this Commission, as it itself observed in its notice for this hearing, the purchase of receivables is a financial arrangement between the suppliers and the utility. It is not between it's not in the agreement between the suppliers and the customer. So that is where I think we need to focus. Now, the suppliers, they note that when they sign up with the utility, they sign what's called a billing services agreement. But and that's when they register to become the suppliers for our respective service territories. However, The billing services agreement for the utilities either make no mention of a purchase of receivables, or if they do mention the purchase of receivables, they make it subject to our supplier coordination tariffs, which this commission reviews and approves. And our supplier coordination tariffs, in turn, when they do talk about purchase of receivables, they say that when a supplier elects to use company consolidated billing, the company will purchase the supplier receivables pursuant to commission rules, regulations, and orders. So in other words, there was never a guarantee that purchase of receivables would be an option in perpetuity. It was always subject to the possibility that this commission could modify those rules. And therefore, the joint utilities do not see how suppliers can claim any kind of a contractual right to purchase of receivables that would be affected by broadening the prohibition to all residential customers. Now, having established that, it's also important to keep in mind that there is nothing in Senate Bill 1 that prohibits the commission or the utilities from modifying the purchase of receivables for all residential customers pre-January 1, 2025. And it's also worth noting that I believe the suppliers, they cited to case law in their comments where they said that when the General Assembly is drafting statutes, it is presumed that they are aware of this commission's regulations and the regulatory landscape affecting a certain issue. So assuming that is the case, then we have to presume that when the General Assembly was drafting Senate Bill 1, they were aware of the fact that purchase of receivables, once again, was a creature of the commission's creation and could be modified by this commission at any time. The General Assembly then had the opportunity to include language in Senate Bill 1 saying that utilities and the commission, you should not modify the purchase of receivables for any agreements before January 1 of 2025. The General Assembly did not do that. I think the appropriate way to think about what the General Assembly did in Senate Bill 1 is that it removed the option of the utilities and the commission to continue purchase of receivables for residential customers after January 1st of 2025. So with that, I can see if any of my co-counsel would like to make any additional comments.
Good afternoon, Your Honors. No, I have no additional comments at this time, but I'm available for questions.
I can't hear what you're saying. Oh, okay.
So let me try this, Mike. Can you hear me okay?
Yeah.
Okay, great. Okay, this is Damon Krieger on behalf of SMECO. Good afternoon again. So we did join in on the comments with the other impacted Maryland utilities, so I won't repeat the comments that Mr. Seeger's made since we're all pretty much in the same boat, in the same position. I do want to highlight a few distinctions with respect to the cooperative, though, that I think are important in the Commission's consideration of this particular issue. First, we all do have slightly different agreements at play, and to the extent the Commission's interested in SMECO's specific agreements, they're all posted to our external website. They're all accessible on the public www.smeco.coop website under the energy supplier link. And the operative agreements for us are the Electricity Supplier Coordination Agreement, the Electronic Data Interchange Trading Partner Agreement, and then, of course, the Electricity Supplier Coordination Tariff. And importantly, nothing in the two agreements references purchase of receivables at all. At all. And so when you think about a contractual relationship, our contractual relationship is as between the cooperative and the supplier. There is no privity of contract when it comes to energy supply between the cooperative, the supplier, and the residential customer that has elected to shop with the third party. So that's an important distinction when you think about analyzing the contractual issues at play. The two agreements that are in play between the cooperative and the supplier reference the supplier coordination tariff as the controlling document with respect to purchase of receivables, but again, without mentioning POR specifically by reference. What's important there, as Mr. Seegers alluded to, is the tariff is subject to change at any time by direction of the commission. And so the contract itself, as between the cooperative and the supplier, recognizes and incorporates by reference the supplier coordination tariff, and as it may be changed from time to time with the approval of the commission. So that's a really important point to make when you think about the plain language of the contract itself, which allows for changes to be made to POR upon approval of this commission. And that was all in place before the passage of SB1. What the statute does, as Mr. Seegers alluded to, is create a bright line as to a point in time when POR must end for residential customers. That doesn't take away the fact that the commission has the absolute right to end POR at any time. It just has to end it by January 1st, 2025. And I do want to, since I have the opportunity to do so today, I think it's an important opportunity for the commission to also think about the impact for commercial POR. That's not specifically at issue in the statute, but it was referenced in our joint comments as at least an opportunity through the course of this proceeding to consider whether POR should also terminate when it comes to commercial customers. The commission did launch a proceeding, PC60, which was then tabled as a result of the passage of SB1. And I think the fact that the commission initiated that proceeding to begin with indicates at least an opportunity to eliminate POR before there was a statute even in play. So there was some recognition through the initiation of that conference that the opportunity to eliminate POR was a positive for customers, or at least had the potential to be a positive for customers. And so when you think about the two sort of core legal issues at play, one is statutory interpretation, one is contractual interpretation. Both align with what Mr. Seegers indicates is the joint position of all of the utilities with respect to the fact that the commission has the absolute right to end POR anytime. It just has to get rid of it for residential customers as of January 1st. The other important, or I'll call the practical consideration for the cooperative, is how many customer members we have that actually take advantage of shopping today. We only have about 2,400 residential customers that currently have an arrangement with a third-party supplier. It's about 2,400 customers, and then about 400 commercial customers. So when you think about the impact from any change to create dual systems or triple systems, it's very impactful for the cooperative. And the original intent of this legislation was directed at reducing costs for customers and our customer members. And so to the extent we end in a place where we now have to maintain 2 or 3 systems because we have POR for commercial, we don't have it for residential, and then we have a split between pre-January 1 contracts and post-January 1 contracts, it gets very complicated. And as I think we've all learned through the years, any change to an IT system, a customer care and billing system, is a monumental undertaking. It takes a lot of resources, it takes a lot of dollars to make even the simplest changes sometimes, or what we may think is a simple change. It ends up being extremely complicated because it's a web. You change one thing, it then changes how the payments are processed, and it goes on from there. So when you think about the impact on the cooperative, I would ask that the commission not only consider the legal issues, but also the practical implications of requiring certain system changes that really are not going to be in the best interest of our customer members at the end of the day. So I'll pause there and happy to take any questions.
Actually, I want to move on to the other utilities, but just one clarifying question. So you said you had 2,400 retail shopping customers of the cooperative
Residential. Our total customers are about 176,000 at this point in time. So the exact number is 2,408 residential and 340 commercial as of July 31st.
Okay, thank you.
Sure.
So let me turn to PE and try that microphone and start talking about what I want to make sure that the two commissioners can hear you before we have to move to another one. So start with that one.
Yeah.
Okay.
Mr. Chairman, let me suggest that I think the microphone should be no more than 4 inches away from the speaker. Otherwise, there's a tendency there'd be sound drops. That's just my opinion.
Okay, we're going to try that. And Did you get? Okay, so go ahead.
Okay. Jessica Raba, R-A-B as in boy A, on behalf of Potomac Edison. Fortunately, I don't have much to say. I hope the mic's working. But
Yes, it is.
thanks to my colleagues for covering the issues. We don't have any substantive legal arguments to add at this time.
Okay. And WGL.
Spencer Nichols, SPENCERNICHOLS, on behalf of Washington Gas. We believe we're in the same boat as the Exelon Utilities and Potomac Edison, and we have reviewed our retail, our billing services agreements with our suppliers and believe we're in the same boat, and we have no other comments beyond those that have already been made.
Okay, so questions from the commissioners. Commissioner Sussman.
Okay, so I guess the question is, who's going to answer my utility questions? And it could be Mr. Seegers who started.
Yeah, we'll do that.
I can certainly try, Your Honor.
Okay, okay. And I can certainly try to hear what you're saying. Okay, so why don't we turn to the COMAR provision? And let's go to Section A. So the utility shall either purchase the receivables or prorate customer payments. So is the utility's interpretation of that you have the option of either purchasing receivables or prorating customer payments?
Yes.
Okay, and that option continues in subsection B.
Yes, that is correct, Your Honor.
Okay, and has and I guess this is sort of the question for all the utilities. Have utilities prorated customer payments for any customers as of today, or do you only purchase receivables?
Speaking for the PHI utilities, Your Honor, no, we do not prorate. I do not believe we have done that in some time.
The same is true, Commissioner Sussman, for the cooperative. We have never approached POR from the perspective of a pro rata allocation since it started with the cooperative,
Okay.
I don't know, 10 years or so ago.
And then PE?
Same.
Okay, so, and then WGL is the same?
Same. Yeah,
Same.
apparently the same.
Okay, so if you get rid of the purchase of receivables option, which the COMAR provisions gives you the option to do. So the utility has the choice of whether they will purchase the receivables or prorate. If purchase of receivables is taken off the table, either because the General Assembly has taken it off the table or the utility has taken it off the table, the COMAR provision still stays in place. It's just that only prorating is the option for a utility. Is that correct?
From a legal standpoint, yes, that is correct, Your Honor. But I would note that we have conferred internally with our IT experts. And in order to implement the systems that we have right now, they're not designed to prorate customer payments, just because none of us have done that in a very, very long time. So those systems are going to have to be designed. And there simply is no way that we can design. Well, first of all, we would need to know the specifications that need to be built in to those systems, and then we would need time to design those systems, implement that, and then there's also the increased cost of that. So while you may be correct from a legal standpoint, from a practical standpoint, it's not a matter of, okay, the utility can flip a switch and just go right to pro rata.
Okay, so but I'm just talking about in terms of rulemaking and rules. The regulations are in place, and the only options the utility has now are either purchasing of receivables or prorating customer payments, and then under the terms and conditions approved by the commission.
Yes, as it stands right now, that is correct, Your Honor.
Okay. Turning to the billing services agreement, is it your testimony that there's nothing in the billing services agreement that requires the utility to purchase receivables?
Once again, for speaking for the PHI utilities, our billing services agreement, it says nothing about purchase of receivables. All it says is that the parties will abide by the supplier coordination tariffs. And that is where it does address purchase of receivables, but subject to the commission rules and orders.
Okay. I guess my question is, if we were to eliminate purchase of receivables for any customer, any retail, any customer of a retail electric supplier, is it your testimony that this would not violate the billing services agreement because the billing services agreement does not require purchase of receivables? It just sets out the conditions where a receivable is purchased.
Just so I understand your question, Your Honor. So, if the commission, if you decided to get rid of all the purchase of receivables, or just
right?
Okay. Then once again, for the PHI utilities, no, that would not violate our billing services agreement. I would say that for BGE, their billing. Okay, sorry.
I missed the last piece.
Well, Mr. Seegers was going to speak on behalf of BG, but I thought I would jump in. BGE, our billing service agreement is slightly different in that we do mention purchaser receivables in it. But it also says that it's purchaser receivables pursuant to the company's tariff, as that tariff is amended from time to time. It also then, throughout that says that the tariff is referenced and is incorporated by reference. So again, while our billing services agreement is slightly different and we do mention purchaser receivables, it is conditioned on what is in our tariff. So if our tariff is changed, the billing services agreement would have to be changed, and it does not guarantee purchaser receivables.
Well, that's why. So I'm just looking at the four corners of the agreement itself, and there's nothing in the agreement that requires BGE to purchase receivables.
No.
Okay.
No, it does not.
Your Honor, this is Damon.
Mr. Krieger, is that the same for SMECO?
Yeah, can I actually respond to your first question as well on the regulation?
Yes, please.
And then the contract as well. And so on the regulation itself, I do want to make sure that we're not starting with the assumption that utility consolidated billing is the right path forward. There certainly are other options on the table, one of which is dual billing, such that the supplier issues its own bill for the energy component and the utility issues its bill as it stands today, less the energy line item. And so the regulation as it stands does talk about two options with respect to utility consolidated billing, but that presupposes that's the right way to go in the first place. And certainly the commission has an opportunity to change that dynamic, and whether it thinks it's best through rulemaking or otherwise, we could move forward, and certainly the cooperative's position is it would be best for our customer members to eliminate utility consolidated billing in favor of dual billing, given the very few
Mr.
number
Krieger,
of customers we have.
Right. The reason I asked the question is because I'm looking to see if there's a way to address the issue without making changes to the rules, given that we have a very short window.
Yeah.
And so to the extent that there is a way to keep the regulations in place and still affect what it is that the utilities are proposing, that's why I asked the question about the prorating.
Absolutely.
Because that does stay in place as an option for the utility. So the utility can decide not to do purchase of receivables, but according to the regulation, the only other choice would be prorating.
Yes. So, Commissioner Sussman, I think that the easiest path would be for us to amend or submit an amended supplier coordination tariff that makes clear that, at least from the cooperative's perspective, we would like to eliminate, again, purchase of receivables altogether and rest on dual billing to the extent that we move forward with any form of third-party supply. And so you could easily amend the supplier coordination tariff to make it clear that, at least at a minimum, to address the specific issue at play, that there is no longer purchase of receivables. It's not an option for residential customers going forward, and our contract, to the direct question, does not say anything contrary to that, because it incorporates by reference whatever the
Right. Well, that's what
whatever
I did want to address the contractual issue, because that was an issue that was raised. And so, and then Ms. Rivas, is your supply, your billing services agreement does not require that you purchase the receivables?
That's correct.
Okay. And then Mr. Nichols, the same thing for you?
Commissioner Suchman, I'm not sure that Washington Gas can make a legal conclusion as I sit here today. However, our billing services agreement is available online. It does reference purchase of receivables. However, we would submit that it, like the other utilities agreements, it's tied to applicable statutes and regulations. It also contains various termination provisions that are available to Washington Gas specifically.
Okay. All right. That's all I have. Thank you, Mr. Chair.
Commissioner Barve.
No, this time.
Commissioner Richard.
I think Commissioner Suchman covered a lot of the area I was interested in hearing from the company, but I would be interested to kind of go and hear from the other utilities. Is it the intention or the expectation, maybe that's a better word, that you will continue with utility consolidated billing into the near future, or is that something that you think should also be relooked at in light of this the poor decision, the poor requirement from the legislature?
Your Honor, that's well. First of all, that's one of the items that is going to be discussed in our filings, which are due on Friday.
Okay.
That is certainly an option, and it's one that this commission once again certainly has the ability to do. What I would just note is that if the commission did make a determination to continue utility consolidated billing, one possibility is, as Mr. Krieger said, is to go to a dual billing methodology. One thing that I would say is that, once again, speaking for the PHI utilities, when a supplier, when they register with us, we confirm that they have the ability to receive usage from us in order for them to render and calculate a bill. So all the suppliers that do business in Pepco and Delmarva Power have the ability to receive that information. So that could be one possibility if the commission determines that utility consolidated billing should continue. But doing away entirely with utility consolidated billing is also an option.
Okay.
A very viable one.
Is that BGE position?
Well, I would just add that, again, the statute requires the utilities to discontinue the purchase of receivables at January 1st, 2025, whether it's for all customers, all residential, whatever. The problem is that having another system of any kind in place by January 1st is not feasible, not practical, not possible. So I think, whether or not utility consolidated billing is something that happens between now and January 1st, or, until I shouldn't say between now and January 1st, to meet the January 1st date, we have to come up with another option other than utility consolidated billing, because there's no way we can have something else in place to replace purchaser receivables. So I think that's when we've been talking about the dual billing option, whether dual billing becomes the standard where we no longer offer utility consolidated billing, or it's just a temporary measure until we can get the necessary system changes programmed. That's for the commission to decide, but I think dual billing is going to have to be in place for some amount of time.
Okay, yeah, that you've kind of jumped ahead where I wanted to find out where the utilities are going, because it sounds like you cannot comply, if I'm hearing you correctly, with the elimination of POR by January 1st. Is that correct? So So for those customers that are retail supply customers, the only other option, is that what I'm hearing you say now, is dual billing?
I think the appropriate way, if I'm hearing you correct, Your Honor, I believe that you are correct. That the only way that the utility that we're going to be able to comply with the January 1 date is through dual billing. That's
Okay.
if that answers your question, Your Honor.
Yeah, well, that's kind of I think a big piece of information. So,
If I may, Commissioner Richard, as well. So the SMECO, the cooperative, is in a similar mindset. The threshold question still is: do we have contracts, relationships that we need to consider post January 1 and pre January 1? Because that certainly creates a layered complication. But similar to the other utilities, it is a practical impossibility for us to have a system in place that would have a pro rata allocation or something different than a straight purchase of receivables by January 1st. So dual billing, whether it's a permanent solution or a temporary solution, really is the best solution from a practical perspective to move forward. That would also certainly, if the Commission's interested in launching a rulemaking to address some of this long-term, to Commissioner Sussman's point, give some more time to sort through those larger issues. But we do think that dual billing is the way to go in order to ensure compliance with that threshold layer. You can't have purchase of receivable post-January 1st.
okay.
So I picked a good seat today because Potomac Edison is aligned with those comments as well.
Just to answer your question directly, Mr. Commissioner Richard, right now, Washington Gas plans to continue utility consolidated billing, but its future actions are going to depend on what the commission guides us to do.
Okay. So the pro rata. Okay, so that kind of takes that question off. So pro rata, moving to that on January 1st, really is not an option so that the customer experience remains the same as far as how they pay for their retail supply bill. At least
As of January 1, Your Honor, yes, that is correct. Just because, as I said before, pro rata is not something that has been done in recent history. It's not designed into our systems. We would have to modify our systems in order to do that. And as Mr. Krieger said, modifying our IT systems is never quick or cheap.
Okay. And just going into the future, community solar is now we're moving toward a utility consolidated billing process. That's correct? Is that how all the companies interpret that? I mean, if that's in place, is that available still then to utility I guess retail suppliers under under a pro rata option? I was just trying to understand if the same IT change would impact both. I'm just trying to understand, too, bigger picture of what the customer experiences will be going forward for retail suppliers.
Right. Unfortunately, I don't have the statute right in front of me, but I think the threshold question there, Your Honor, would be how does the statute, how does it define a supplier? If that is just like a retail supplier, just in thinking, I would not think that would include a subscriber organization, because under community solar, that is who the utility would be purchasing a receivable from. But again, I think how the term supplier is defined in SB1, I think that's going to be the threshold issue there.
Okay.
And with respect to the cooperative, we are exempt from the community solar requirements, so we are not participating in that program. So again, another sort of nuance specific to the cooperative.
That's good to know. All right, I think the only other thing I wanted to find out from the utilities, this SB1 can contain a number of customer protections in it. One being that the contract cannot auto-renew, and it could only last for a year. So, I mean, I guess just theoretically, is it possible to say, even if everyone renewed on December 31st, that within a year, everyone would, at that point, be on, they would, for them, the billing would end. Is that how you read the law? Looking for a date when it definitely is going to come to an end.
Yes, I believe that is correct, Your Honor. Even if this commission, if you determine that that only agreements that are new, that are entered into or renewed after January the 1st of 2025 are affected by the purchase of receivables prohibition. The grandfathered agreements, those would eventually expire. So at some point,
It expire in 1 year, right after that.
well, and this is an issue that we raised in our comments, Your Honor. The utilities don't know, one, which agreements have been entered into or have been entered into or renewed prior to January 1, 2025, nor will we know how long those agreements are going to be for. If they're going to be for 1 year, if they're for 2 years. That's one of the problems about grandfathering those agreements from the prohibition, is that as it stands right now, the utility has no way of knowing which contracts those are, and we have no ability to require suppliers to give us that information.
Okay.
That's certainly the same for us.
Okay. All right, I think that's it. As far as the information needed, is that something that you believe we have the authority to do? The commission has the authority to say, okay, the retail supplier needs to provide the utility, an affidavit of some kind that a customer is eligible for POR because of the date that they renewed their contract?
Your Honor, I think you do have the ability to require the suppliers to do that, but I think what would have to happen, it's not enough for them just to give us an affidavit. We would have to change our EDI transactions because, again, we'd have to be able to tie that into the billing. When we get a transaction for a charge to be placed on the bill, we would have to know with that if that particular contract, that particular transaction is for a contract entered into before or after that date. So it wouldn't, getting an affidavit would not help us because that would be then a manual situation. We need to have an EDI transaction that indicates if it's before or after January 1st, so that our billing system would be able to differentiate and be able to send it down the right path.
I guess what I'm asking is, wouldn't that be just a status quo customer that you just go under the assumption that no one is eligible for POR unless there's an affidavit that says, no, this particular customer continues as they're currently being billed?
But again, an affidavit is not going to be tied to our billing system. And so when we get all of our transactions for bills, charges to be put on the bill, are done through an EDI transaction.
Okay, they can't just be designated as a POR eligible
we would need
customer.
To have something within the EDI transaction designating it as such. So we would have to add probably a field in the EDI transaction that gets sent to us that says it's a before or after. But then again, the problem with that is then we have to have modifications to our billing systems and maybe even the customer choice systems that say, okay, I have this EDI transaction now that says I need to bill $100 for this supplier on this customer's bill. This is a pre-January 1st contract, so this now has to go down the purchase of receivables path, or the opposite, this is a post-January 1st transaction. This has to go down the pro rata or whatever else the commission does. So again, we'd have to build in the functionality to have the system distinguish based on that characteristic and then have it go down two paths. So again, we're saying we can't even get the pro rata programming done by January 1st. So, then adding in the being able to distinguish between the two and having dual systems, basically dual payment allocation methodologies, is something that absolutely we cannot get done by January 1st, 2025.
Okay, it kind of answered my question. I guess I was just saying that this is a limited time period where there would be POR eligible customers, or they would have to, since you're saying they'd have to go to a dual billing system, that they would not be eligible. So make it very simple.
Right, but we'd still have
Status
to do
quo.
the same programming, and we'd still have to get it done by January 1st.
Okay. All right. Thank you. Thank you, Mr. Chair.
All right, just in a sense of trying to fill in the picture completely, one of the, rough justice agreements that was done in the last legislative session when it came to this bill was to attempt to exempt the commercial customers, because the thought was that they were actually perfectly happy with retail supply and didn't necessarily want any changes. So along the lines of some of the discussions you've had about things that you need to do from a practical standpoint, are there sort of unintended consequences of decisions that we make regarding the residential customers that might impact the commercial customers that we should be aware of? You know, what I'm looking for is, and maybe you need to provide a supplemental filing on this, but I guess I want to know if there's things that we need not to do so that we don't impact what's your relationships and the retail suppliers' relationships with the commercial customers if we try to do something on the residential end.
Mr. Chairman, I will say that I'm not aware of anything that that would affect the purchase of receivables for our commercial customers. I would note that a portion of commercial customers already do dual billing. So, but we also we're certainly going to maintain our system to do purchase of receivables for commercial customers. Again, I'm not aware. I will certainly, I'll certainly inquire, but I'm not aware of anything as I sit here today.
Okay. And I guess just down the line.
Your Honor, I'd say, I don't think there's anything that would have to, but I do think at some point the utilities would, again, have the choice under COMAR currently whether or not we purchase receivables or we do pro rata or whatever other method the commission might choose to go to. We may decide that we want to go to that other option so that for commercial as well, so that we're only maintaining one payment allocation methodology.
Yeah, I think that's very similar for the cooperative. We have a system in place. It's for all customers that requires us to purchase receivables. And so to the extent
I'm sorry, I didn't hear that at all.
Is that better? I'm sorry.
Yeah, that's a little better.
Thank you for
Start
letting me
again,
know. So let me start again. So I think that
that's the problem. You get too close, you get the feedback. So you have to find the sweet spot.
I'll try this. So I think from the cooperative's perspective, very similar. We have a system in place that's applicable to all of our customers that requires us to purchase receivables. And so going forward, if we were to maintain that system, well, we already have it. The problem is we would have to maintain two systems. And then again, as I said before, to the extent you have the split contract, a third system. So certainly the preference would be to have one system in place for all customers, whether that's pro rata or dual billing, the preferred option for the cooperative. That would be the preferred option.
So for Potomac Edison, the same is true, but to answer your direct question, I'm not aware of any unintended consequences as I sit here, but we will think about that and let you know if we come up with something.
That's the same for Washington Gas.
Okay. All right. Thank you very much. So now, why don't we turn to the retail suppliers and also SFE, and then we'll bring up energy advocates too. Yeah. Strange bedfellow.
Sure. It's
Oh, does that work? Okay, sorry.
Hi. My name is Brian Green. It's Brian with an I, and Green, Greene. And I'm here on behalf of the Retail Energy Supply Association, NRG Energy.
Before you start,
And can you guys hear me?
We cannot hear him.
so I think the secret is you have to pull it close to you,
Okay.
but not.
I thought I was really
not
close. I
right
thought it was
on
in
the
that
top,
4 to
so-
6 inches
yeah,
range.
So there's
Is
a
this
magic
better?
spot there.
Is that better?
Yeah.
Okay.
Does that work? Go ahead.
Okay. I'll keep going,
Better.
and please tell me if can everyone hear me? Commissioner Suchman,
Yeah,
can you?
I can now.
Little closer.
All right. I feel like I'm going to eat it. If
I know. I understand. we want everybody to hear what you have to say.
All right. Okay. It's Brian Green on behalf of the Retail Energy Supply Association, NRG, and Clean Choice. I think one thing that has struck me about the comments and about the written comments and the utilities comments today is that this really is all about the transition to the post-residential POR world. First of all, I think it needs to be said again that staff, OPC, and the suppliers agree that under SB1 residential supply contracts, the POR associated with those contracts survives after January 1st, 2025 for contracts entered into before that date. So the question is, how do we get there? Like, how do we get to the complete elimination of residential POR? And I think in our view, the General Assembly told us how to do it. They said for new and renewed contracts starting in 2025, no residential POR. Everything signed before that date gets POR. And the conversation ends there because the legislative intent is so expressly stated that we're told what to do and it's up to us to get it done. So with that initial position, the suggestion has been made that the commission just have a rulemaking and end residential POR or all of POR on a date certain, including for contracts entered into before January 1st, 2025, which is exactly what the General Assembly said you cannot do. The General Assembly has spoken. It's told us how to make the transition to this post-POR world, and a rulemaking would simply be an end run around the express legislative directive on how to do this transition. I would also point out that a regulation with a blanket end on a certain date and impair the existing contracts raises the same constitutional issues that we didn't delve into detail on in our written comments, but we highlighted that it's an issue. And that's why these contracts are grandfathered, so that you don't start flirting with the constitutional contracts clause. Mr. Seeger, especially the utilities, said that the General Assembly is presumed to be aware of existing regulations, and I think it was aware of existing regulations in the Commission's authority when they adopted SB1, and they said, we're going to do this in a transition. We're going to get there slowly. We're not going to do it all at once. And so just changing the regulation, the General Assembly knew about the regulation. You have to at least presume that. That's the law. So I disagree with the Utilities Council on that, on what exactly they are presumed to know and how they carried out that presumption. And then the final thing on this one particular point is that going to a strictly dual bill avenue or path would be, and I don't know how nicer way to say it, it would be a nightmare. Customers all of a sudden who don't, in the testimony since 1999 has been residential customers don't like dual bills. And so all of a sudden, at some given point, and the suggestion has been made that that happened on January 1st, a customer is going to get a separate bill from their supplier and another bill from their utility. And they're just going to have to know what it means, why they're getting this separate bill, and am I supposed to pay it? I've never gotten this bill from this company before, from my supplier. It was always on the other bill. What's going on? I also think that there are numerous suppliers that don't have the ability to send a dual bill. So how do they bill their customers? So it presents a dual bill scenario, even if temporary, presents a serious question and problems that you're going to see a spike in CAD complaints. You're going to see a spike in call center calls to the utilities and to the suppliers. I don't think it's going to be good for anyone. The other alternatives are the continue with the utility consolidated bill or the supplier just drops the customer, in which case you're going to get more calls because of a reverse slam. So the best path forward is to continue the utility consolidated bill in some form or fashion, and allow these customers to continue to receive one bill from their utility with all the charges on it. And then my next point, there were questions about and the utilities have stated that they have no way of knowing which contracts are being renewed or are ending, and they're right, except that for new contracts after 1/1/25, they will know, right, because they'll get a new enrollment, right, from a customer that was not already enrolled. For a renewed contract, they won't know if there's a renewal that shouldn't have POR attached to it. So the answer is that if you look to RM 78 for guidance, that's the low income implementation and monitoring that the Commission has in place. Suppliers just 2 weeks ago were required to send in information to staff identifying their contracts, when they were when they're grandfathered for those particular low income customers, and when which quarter of the year they are ending, so that staff can keep track of it. And I don't know who else, if I don't think the utilities get that particular report. But my point is that there are mechanisms in place that where this transition can be tracked and monitored. And so it's not a throw your hands up in the air and make them dual bill kind of situation. Or nor is it a get rid of POR for everyone type of situation, because we feel like there's a way to get through this. It's just going to involve everybody. And Commissioner Richard, you asked about when does it all end, and that was a good question, and you almost had it. If it will just depend on when is the longest contract that is out there in the market pre January 1st, 2025. So if tomorrow someone signs a 2-year fixed price contract, then that contract would be grandfathered for the full 2 years of the duration of the contract. So, and that contract should, under SB1, be left untouched, and POR should continue for that long. But at some point, they'll all phase off, and then we'll eventually just have a handful of contracts, and then it'll go away. So, I just want to check my notes and make sure I don't repeat myself here. I may have already said this, so if I did, I apologize. But the argument from the utilities that they can't maintain two different systems, one for POR and one not for POR, I appreciate that that's hard to do, and I don't want to underestimate. I don't want to. I'm not trying to poo-poo the situation, but the General Assembly said do it that way. So the answer is not get rid of it for everyone, because the utilities, it's too difficult to implement, or it's difficult to implement, or it costs more. The General Assembly told us how to do this transition. And then finally, just a couple of smaller points. And there was talk about the billing services agreement. So the billing services agreement, and we were very open about this in our written comments. It's certainly not our strongest argument. It's not what we want to hang our hat on. But we wanted to point out that at least for BGE, there is a written agreement. You can find it online by Googling BGE Billing Services Agreement. You can find the template. In that agreement, BGE specifically agrees to purchase the receivables pursuant to the tariff as amended from time to time, for as long as the supplier is on the utility consolidated billing system. So we pointed out in our comments that yes, that does envision that the tariff would be amended, but it doesn't contemplate that POR would end completely. So to the extent that's a distinction, we wanted to make it. We think it's important. We think that there are still, if regulations are changed, it raises the same constitutional issues because of the supply agreements in addition to the billing services agreement, although I understand that the stronger argument is definitely with respect to the supply agreement, not the billing services agreement. And then the only other thing I would point out, and I don't know if there's overlap here or not on these two things I'm about to point out, but I wanted to point them out nonetheless. So the pro rata alternative that was adopted in the 2009 time period that gave the utilities the choice to choose POR or pro rata. In RM 70, just a few years ago now, for supplier consolidated billing, the Commission adopted for SCB a pro rata system. So the utilities are in the implementation phase and programming phase of that now. I don't know if there's overlap between that system and a UCB system, but pro rata going back to 2009 and SCB is not new to the Commission. And then finally on the billing services agreement, I don't know if they still have it, but BGE had a system in place over the last several years where a supplier could sign a separate agreement and pay for a fee and have BGE include items on the bill outside of POR. So they had a system in place to carry items on the bill outside of purchase of receivables program, and then they had the other items on the bill that were the supply services that were subject to POR. So again, I don't know if there's carryover from that system to what we're talking about, but it doesn't seem novel if they already had that system in place for the last several years where a supplier could carry an item on the bill outside of POR and to now say that it's impossible to do. So and again, I'm not an IT guy. I'm just pointing it out that system has been there, and there may be some overlap. So with that, I would ask. That concludes my comments. I'm certainly available for any questions, but I would strongly recommend, as we've said in our comments, that the General Assembly has told us how to do the transition. It's not going to be easy. We've recognized that from the get-go. As soon as the beginning of SB1 is going to be a bear, and it has, and it will be. But it told us how to do it. Now it's up to us to get it done.
Okay, actually, let me go to safe energy.
Good afternoon, Chairman Hoover and Commissioners. Okay. Sorry, redo. Good afternoon, Chairman Hoover and Commissioners. I'm Stacy, Stacey, Rantala, Rantala, appearing on behalf of SFE Energy. SFE Energy submitted comments in PC65 and appreciates the opportunity to participate in the hearing today and to respond to the other stakeholder filings that were submitted. In our comments, we did note our support for the RISA, Clean Choice, and NRG comments, so what I'm saying today is largely in response to the other filings that were made on Friday. A review of those submissions shows agreement of many parties that SB1's residential POR prohibition applies prospectively to contracts entered into after January 1st, 2025. The prospective application of law is an important principle. Prospective application of law is important for promoting finality in transactions, fair notice, reasonable reliance, and settled expectations. Applying a law retroactively creates new legal consequences for prior actions and upends those expectations of finality, fair notice, and so on. The Maryland legislature, by the plain language of SB1, sought to make the law prospective in application, presumably for those very reasons. However, OPC, while recognizing that SB1 applies prospectively to the residential POR prohibition, made an alternative suggestion that the Commission retroactively change its regulations to ban residential POR for all accounts. the utilities suggested that the Commission issue an order to retroactively ban residential POR for all accounts. SFE Energy urges the Commission to reject those proposals. The retroactive application of regulations is just as harmful as the retroactive application of law. Rewriting the regulations to retroactively ban POR will interfere with suppliers' contracts with customers that were entered into based on justifiable reliance on the rules as they existed at the time. It would potentially also raise constitutional issues. OPC also suggested that the Commission adopt a retroactive POR rule change on an emergency basis, but they identified no actual exigent circumstance to justify an emergency rulemaking. And a full rulemaking would still be required to change the regulations on a permanent basis. There's a substantial amount of work required to implement what SB1 does in fact require. Stakeholders should focus on that rather than diverting resources to retroactively change regulations which SB1 expressly did not change. With that, thank you for the opportunity to participate.
Okay, so let me actually go to questions for the retail suppliers, and then I'll turn to energy advocates. So, Commissioner Richard.
Yes, thank you, Mr. Chair. Mr. Green, yeah, thank you.
Commissioner Richard, before you start,
I will pull it closer to my.
Thank you.
Okay. Sorry. You're not the only one who gets chastised. Let's see. Yeah, I wanted just a little more about this. You know, what the agreement entails between you and the utilities, and then also what your contract with the customers. So you heard what the utilities had to say about their the billing services agreement, and it sounds like there's a it's not ironclad that they have to continue with the purchase of receivable, particularly given the legislative mandate. Did you have anything specific to comment about what they had to say about the billing services agreement?
Well, I think what I wanted to comment on, I think I hit, which was that I think from a higher level, BG probably has a more detailed agreement than the other utilities do.
Right.
And BGE specifically obligates BGE to purchase receivables pursuant to the tariff as amended from time to time. And so, like I said, in our comments, we noted that that doesn't contemplate ending the program. That contemplates that there might be a change in how the discount rate is calculated, or it could be, that the discount rate changes every year. That's really what we thought it contemplated, and not a termination provision.
Okay, and then about the customer. When you have a customer, I mean, is that specifically in the contract that there's this thing called purchase of receivables, and it's important that, or right. Does the customer? They're kind of indifferent. They just get their bill every month, and it contains the commodity.
Right. So I in pretty much all of the supply agreements that I have seen, do not mention purchase of receivables. They have a whole paragraph on billing, and you'll get the bill from the utility, and it'll have your charges on it, and you should pay the utility, on time and so forth. I think what we pointed out in our comments is that where POR comes into play and why it was adopted was to put the supplier on a level playing field with the utility in terms of the risk of uncollectibles. And so if we didn't have POR, the supplier most likely would have credit screens and deposits. The pricing would be different. They would have to, and so all of that is factored in a supply agreement before it goes to the customer. So if you strip that out, suddenly there's and I should say that one of the reasons for this back in 2009 was that the utility would purchase the receivable, and then the utility had that stick of termination, in order to encourage payment.
Mm-hmm.
The suppliers don't have that. So there was, in the old days, right, I think the utilities would carry the supplier charges on the bill. I think it was 90 days or 3 billing cycles, something in that range. And then if there was not collected, or whatever portion was not collected would be kicked back to the supplier, and the supplier would have to collect it. And so we adopted the POR or pro rata, which was deemed more fair to the supplier and to encourage competition and to, and it worked, right? It brought more suppliers to Maryland.
Okay. If I could just, I guess what I'm trying to get to and hear your answer is, we've been given a mandate, and I don't think any of us want to frustrate the intent of the legislature, and they said to end POR, and by August 1st. Is there anything explicit though in the contract with the customer that says POR has to be there, purchase receivable has to be there, that's being violated if the utilities were to just and purchase the receivables on January 1st in 2025.
Yeah, I mean, the only way I can answer that, Commissioner, is to say typically no, but there may be contracts out there that address POR specifically. I have not seen them.
Okay, and then just as far as the intent in the legislation to stop auto renewals and to limit everything to 1 year. So, I mean, would we be frustrating the intent of the legislation if we were to presume that, even today you could enter into a contract that would not, fit that requirement, when it's basically pretty clear that the legislature wanted to end anything beyond a 1 year in duration?
For contracts that are signed
Today,
after January 1st, there's a 1 year duration in for electricity. It's in section 7-510D.
So to take the extreme, could someone go out there and say, this is a lifetime contract, you sign it today and they're stuck with that, or what?
I want to say yes, but I don't know anyone that offers lifetime contracts. So I think people are struggling with 3 to 5 year contracts and always have to get the pricing right.
Yeah, well, it seems like,
Right.
again, there's a protection, not just the duration, but also the fact that the price has to be at the or below a 12-month average. It just seems like if we're not careful how we're interpreting this law, that we could be, again, frustrating the intent of the legislature right now if we don't, approach it reasonably.
Yeah, well, I'm not the all-knowing when it comes to suppliers, but I'm not aware of any company going out and making a mad rush to sign up as many customers as they can on really long-term contracts right now.
Okay.
So I'm not aware of it. I don't know if it's happening, but I'm not aware.
Okay. And okay, you may have just answered my last question. Is there any kind of education that's going on, at least from the retailer side, about this change, so that people are aware that that these new protections are going to be in place? Because I guess it would be almost irrational for anyone to sign a contract right now, knowing or a contract that goes beyond 2 years. If by your interpretation, they're just kind of undercutting their ability to take advantage of these customer protections. So is there anything that's happening on the retail side to educate people?
I can only tell you that we've had, with my clients, internal conversations about it, some of it thanks to all the orders and notices that have come out in the last month. But we've had internal conversations with our clients, but I'm not aware of any broader type of educational efforts going around.
Okay, well, thank you. And state-wise, did you have anything, same questions if you wanted to answer differently, or?
I think he answered the questions as I would have done, so.
Terrific,
no.
thank you. Great, thank you. Thank you, Mr. Chair.
Commissioner Barve.
No, I don't think so. Not yet.
Commissioner Sussman.
Thank you, and good afternoon, Mr. Green. First I want to talk about SB1, and what SB1 provides in terms of the purchase of receivables, and both Section 7-604.2 and Section 7-510, one for a gas supplier, one for electricity supplier, provide that that the receivables may not be purchased by the utility. But it doesn't, there's no grandfathering in the codified language. Is that correct?
In the codified, correct.
Right. No, I'm going to get to the uncodified in a second. But in terms of the codified language, there is nothing in there about grandfathering in existing billing supply agreements, correct?
Correct.
Okay. But so then we look to the uncodified language, sections 7, 8, and 9. And it's your argument that these sections create a grandfathering of existing contracts, correct?
Correct.
Okay. And the language does say in those sections that that the act only applies prospectively and shall have no effect on or application to any electricity supply agreement or gas supply agreement. So those are the agreements between your clients and the retail customer, correct?
The supply agreements, yes, ma'am.
Right. There's nothing in the uncodified language that talks about the billing services agreement, correct?
Not directly.
Okay. And in questioning and in response to questions from Commissioner Richard, you said that there's nothing in the supply agreements that deals with the purchase of receivables.
That's right. Typically, the supply agreements do not call out purchase of receivables.
Okay, so I can understand the grandfathering language in terms of preserving electricity supply agreements and gas supply agreements. I don't really understand how this grandfathering language then applies to billing services agreements, regardless of how you interpret that agreement in terms of the purchase of receivables. So maybe you can walk me through that.
Right. So I think it's a combination of Section 7 and Section 9. Section 7 is the broader, you can't impair any obligations or contracts, right? And that certainly would encompass the billing services agreement. And then if you look at Section 9, I look at Section 9 in two different parts. First, it says, this act shall be construed to apply only prospectively, right? And then it shifts and talks about the supply agreements. So I think the first part of that, especially bolstered by Section 7, speaks to you cannot impair any obligation or contract, that we're going to apply this prospectively. And so that's where we believe the billing services agreement comes into play.
Well, but that could be, prospectively could be then any agreement dealing with anything. You're asking that we take the codified language, which has no discussion about grandfathering, and then we go to the uncodified language, which only talks about grandfathering in terms of electricity supply agreements. And then you're asking us to then interpret that in a way that brings into play the billing services agreements. And it just seems to me that if the legislature were so concerned about a grandfathering, they'd stick it in the language that's codified. Or if they didn't put it in the uncodified language, at least, or if they didn't put it in the codified language, at least put it in the uncodified language when you're talking about electricity supply agreements. But the fact that they didn't put it in either, and then you're looking to that sort of broader language about shall apply only prospectively, and you want to bring the billing services agreement into that where it's not referenced at all, I think that's kind of unless you can make a better argument than you made, it seems like a bridge too far in terms of statutory interpretation.
Well, I did say it wasn't my strongest argument, but
Well,
I
but the
would
problem
say
with that is that if it's not your strongest argument, then I read the codified language as eliminating the purchase of receivables regardless of when the billing services agreement was entered into.
Well, I think if you look at it that way, though, Commissioner, then you're reading Section 7 completely out of the law. Because otherwise, what does it apply to? We can't just pick and choose what contracts and obligations we want to grandfather and which ones we don't.
I think it's what it was saying is that we're not going to just get rid of these supply agreements because we are trying to protect the consumer, and so and I don't know what else is in the supply agreement. So there could be other language that could be interpreted in a way to cause heartburn for the gas customer or the electric customer. All I'm suggesting is that the legislature, I would think that the legislature, especially when they spend so much time on SB1, and they put in some language that specifically grandfathered in agreements, and they named those agreements. It seems to me that they would have been careful about including other agreements like the billing services agreement, if that was their intent. And the fact that they didn't, I learned in law school and subsequently that when you include some things, it's intended to exclude others. And the fact that the billing services agreement was not included in this uncodified language suggests to me that the legislature only intended to grandfather in the electric supply agreements. And because, as you said, there's nothing in those agreements that deals with the purchase of receivables, I would read, at least at this point, I would read the SB1 as eliminating purchase of receivables regardless of when those contracts were entered into.
And I would also point to Section 8, where it's very clear, it points directly to 510D and 604.2C, that those sections apply, which is where the POR prohibition is found, prohibitions plural are found, that those are construed to apply to agreements entered into or renewed on or after January 1st, 2025. So it's specifically citing those sections where the POR prohibition is found and saying only beginning in 2025.
Well, I understand that, but we're also talking about whether the utilities are going to purchase the receivables, and it would have been good if the language had been more carefully drafted, I think, but it just seems to me that because we've got two different contracts going, we've got the contract between the retail electric supplier and the customer, and the retail electric supplier and the utility. In terms of the billing services agreement, there's nothing in this language that grandfathers in the purchasing of receivables from the utility, and except the COMAR provision. And so if we were, for example, to eliminate the COMAR provision, then regardless of what's in the supply agreement, the utility does not have to purchase receivables.
I just, with all due respect, Commissioner, I just fundamentally disagree with that. I think the General Assembly has told us
that's all right.
how to do it. And
that's what you get paid to do, and that's fine. And I'm not dismissing. No, I understand what you're. some of these questions, Mr. Green, are for me to also better understand these provisions. So when we make a decision, we're making it based on the best arguments. So, on some level, that's kind of why I'm pushing back, because I need to better understand. And the last thing we want to do is make decisions that are not based on the law and the facts. And so that's kind of why I'm just still I'm not clear about the relationship of the grandfathering provision to the billing services agreement. And that's all I have, Mr. Chairman.
Okay. Is it your view that this grandfathering was done because they realized that they were making a fairly substantial change to the current relationship between retail suppliers and customers? That going forward, that the rules were going to be radically different. That what they were attempting to try to do was to sort of put a place in line when the new rules and regulations take effect on those contracts going forward, but can't be applied retroactively.
I wasn't there in Annapolis every day, so I don't know all the conversations. I watched some of it on TV, on the streamline, on the live stream. I don't mean to be repetitive, but I feel these are big changes. Mm-hmm. It's a whole new marketplace starting January 1st, and not just with these provisions, but with others throughout the bill. And the General Assembly probably understood that, and so they put a transition method in place where they said, we're going to, under these two provisions, 510D and 604, we're going to protect existing contracts, and the new rules will kick in starting January 1st, 2025. Does that answer your question?
Yeah, I think so. All right. So let me turn to Energy Advocates, and Ms. Peltier, just spell your name for the court reporter. And try and pull the mic as close as you can. And I think if we get feedback, well, it's too close. So that's what we found out. So. Yeah, push the button first. Yeah.
I'm testing. Can everyone hear me? Great.
Actually, I'm getting head shakes from. So I guess either speak
okay,
a little louder or.
Does this work? Is this loud enough to hear what I'm saying? Can you hear me now?
I'm struggling.
I can.
Okay.
Yeah.
Are you sure? Do you want me just to change the mic?
No, I think.
Okay.
Just pull it just a bit closer.
Okay. Hi, I'm Laurel Peltier. That's spelled Laurel, and my last name is P as in Paul, Eltier. I am the chair of Energy Advocates and am familiar with what happened in Annapolis, and so I have 5 points. Our written comments follow really the line that the law was pretty clear that. Anyway, sorry, there was a phone going off in the back. Mm-hmm. That retroactive applied to existing supplier customer contracts. I can say that I've read hundreds of supplier contracts from every single supplier. I've never seen anything mentioned about purchase of receivables. And I would even say it took me 2 years to even figure out what purchase of receivables was. So we really followed the line that this purchase of receivables was a mandate by Public Service Commission in 2009. It had nothing to do with Annapolis back then. And I don't know if this is hearsay, but I spent quite a bit of time talking to many people from that era about purchase of receivables, what its intent was. And I heard from many people on the inside back then that this was a way to get the market started, and that it was intended actually to be short term. There were many people saying it would have surprised me that we're 14 years later and we're still using purchase of receivables. I also contacted both Senator Augustine and Delegate Crosby, but Senator Augustine was the legislator because SB 1 was used in both the House and the Senate. And this I have on email, and basically it was a very short quote. The intent of the law was that POR is finished on 1/1/25. If that provides any intent on what the legislator meant. And then lastly, I just wanted to note for everybody that the balance of the contracts that I see actively sold right now are in the 1, 2, and 3 year range. And I see at least one supplier offering 60-month contracts right now. So I just thought it would be interesting to hear what the intent was, because I'm hearing a different version of what the intent of the law was. So I hope that helps.
Questions for Ms. Peltier. Commissioner Barbe.
Yeah, thank you, Mr. Chairman. So let me just be clear about your position. I take it that your position is that we should focus, for the most part, on the codified sections of SB 1 and only regard the uncodified sections as at best explanatory. Would that describe your position with respect to SB 1?
Well, I think the uncodified works with the codified, and the uncodified only is part, it specifically says that it's for the supplier customer contract, which doesn't have anything to do with purchase of receivables. Purchase of receivables is a different mandate between, it's a billing procedure that was a, commission regulated. So we just followed, we feel that it all works together, that it doesn't say.
Maybe
did I answer that?
Perhaps I didn't ask the question correctly. So let me try to ask it again. And that is that you would have us focus in primarily on the codified section where it says that the purchase of receivables would be disallowed, and you don't see the uncodified section as contradicting that.
Yes.
Okay, thank you.
Commissioner Sussman.
I actually found the presentation very helpful, and so I have no questions. Commissioner Barbe actually asked my question, so.
Commissioner Richard.
The same, yeah. I think you've answered all the questions that I've raised today, and I thank you for your submission and your presence. Thank you.
Thank you.
Okay, well, thank you very much. So now let's turn to OPC, and actually, why don't you either go there or there, your choice. So. Go right ahead.
All right, good afternoon. Is this a good volume?
A little
bit more?
Yeah.
Okay. Good afternoon, Chairman, Commissioners. Jacob Auslander, it's J-A-C-O-B, and the last name is Auslander. It's O-U-S-L-A-N-D-E-R. I'd like to begin my comments by just pointing out that the retail choice has been abysmal for residential customers. Residential customers have been overcharged by tens of millions, if not hundreds of millions of dollars, and that prompted the General Assembly last session to pass sweeping legislation to protect the public from the predatory practices of retail suppliers. Many comments have been made today about the effect that SB 1 has on retail choice moving forward, and it obviously does have a great effect on retail choice moving forward. But the statute does not state that POR should continue past January 1st, 2025. It simply says that it will not operate to prohibit POR for contracts in effect before that that were entered into on or before December 31st, 2024. That is not a mandate. That is simply saying that it's simply limiting when the act itself will be effective. Nothing in SB1 affects this commission's power or authority to act in the public interest as it sees fit. And as you've heard from the utility stakeholders today, it is in the public interest to end POR for all residential contracts beginning on January 1st of 2025. I'd also like to make a few remarks about some statements that Mr. Green made regarding the possibility that the commission acting to prohibit POR beginning on January 1st, 2025 will somehow raise a constitutional issue, that it will somehow violate the clause of the Constitution that prevents contracts from being impaired. And I want to state that that is not the law. And if the commission would like further briefing on that, I think that would be helpful. But there is no constitutional prohibition on this commission acting under its validly delegated powers. You would be exercising your police powers to protect the public, and there is no constitutional issue, assuming that you agree that the billing services agreements that suppliers have with utilities are in fact contracts or bestow some type of property interest in retail suppliers. And for that matter, nothing stops the commission from acting today to prohibit a purchase of receivables. But I think that what the utility stakeholders and OPC have proposed is that the commission take whatever action is needed to have POR end on January 1st, 2025. I'd also like to make a few remarks regarding Ms. Rentala's comments about OPC proposing that there would be a retroactive application of these laws, and I don't understand her reasoning. The action that we're asking the commission to take would be prospective. It would say that on a certain date moving forward, POR is no longer available. We are not asking the commission to claw back any payments that have been made by utilities under the purchase of receivables mechanism to date. So I just do not understand that argument at all. And I'd also like to comment on the remarks Ms. Rentala made that our comments suggested that the commission could act under its emergency powers if it felt that changes to COMAR were in the public interest. We did include a discussion of why the commission should exercise those emergency powers, and one of the reasons was echoed by the utilities today, that it's simply not going to be possible for utilities to fully comply with SB1 or change their systems in time without changes either being made to COMAR or some direction from this commission approving the utilities election to stop POR as of January 1st, 2025. And I'd like to end by just pointing out that POR basically created a situation where suppliers face zero risk for over a decade. That didn't mean that they weren't under risk. They were always under risk that the commission could change its regulations or direct the utilities to alter their tariffs or billing services agreements, as OPC and the utilities are asking you to do now. So I don't think that any principle of fairness is raised here either. I think that what the commission is faced with is a clear indication from the General Assembly that significant reforms to the retail choice market were needed. They prescribed certain changes, but they did not limit your ability to act as you see fit to add any further protections or restrictions that you feel is in the public interest. And with that, I'm available for questions.
Okay, thank you very much. Commissioner Sushman. Actually, I think you're on mute because I can't hear you.
I am on mute. I'll get rid of my hand. Okay. So good afternoon, Mr. Auslander. You can turn to your comments on page 8. So this is the first full paragraph, the last sentence. Thus, reference to this extrinsic source adds further weight to the conclusion that the POR restrictions in SB1 have no legal effect on supply contracts other than those that take effect on or after January 1st, 2025. Can you go into a little bit more detail about what you mean by I'm having trouble sort of understanding why the restrictions are only relate to contracts that are in effect on or after January 1st, 2025. So can you explain to me the argument for why the POR restrictions may remain in place, but can only apply to those contracts, but won't apply to contracts entered into before that date?
Certainly, Commissioner. And just to clarify, our interpretation is that SB1 only prohibits POR after that date, not that that the Commission is prevented from acting prior to that date. But to answer your question, it's Section 8 of the uncodified section. It states that sections 7-510D and 7-604.2C of the Public Utilities Article, as enacted by Section 1 of this Act, shall be construed to apply to all electricity supply agreements and gas supply agreements entered into or renewed on or after January 1st, 2025. And
right, but if we heard that POR is not in the supply agreements, then I'm sort of still trying to understand how that brings into play POR.
Because the wording of the statute is not whether certain it does not actually pertain to electric or supply agreements. It's saying nothing in this section that we've revised is going to apply except for agreements from that date forward. So basically, you could just ignore like 7.510D and 7-604.2, and it says C in this uncodified section, but as we explained in a footnote, we believe that they meant B. But nothing in those sections applies. It's as if they don't exist except for agreements that are entered into on or after January 1st, 2025.
Okay, but I'm assuming OPC would support an argument that applied the restrictions on PORs to all electricity supply agreements.
We absolutely do, and we would be happy if that happened today.
All right, that's all I have.
Commissioner Barbe.
I think in this case, Commissioner Suchman asked my question. So nothing.
Thank you.
Yeah, just maybe just one thing. Going to Section 7, I think you had a chance to hear Mr. Green talk about the, we should do nothing that impairs any contract after or before January 1st, 2025. Did you find any of that argument, compelling? That if a product, a particular product, a retail supplier has proffered to a customer, and it's based on the idea that that it doesn't have the time limitations or the renewals or any of the caps on pricing, that if we were to apply then all the rules after January 25th, that would be an impairment. That would be something that was explicitly directed by the legislation for us not to do.
I don't think that it was because of 7. I think that it's because of 8. But
am I getting the wrong one? I'm sorry.
Yeah.
I thought that was the impairment.
I do think that it is the most valid interpretation of this statute is that those provisions only apply, the ones that you just mentioned, only apply to contracts entered into or renewed on or after January 1st, 2025. But I also want to just take a step back because I think one of the first parts of the question that you asked me suggested that this SB1 was some direction to the Commission to not act before then. And as I tried to explain, that is not the case. This Senate Bill 1 does not
limits your abilities, except for the express direction to take certain actions to do make certain changes. So I just wanted to make that clear. And the operative wording in all of these sections that I think are at issue today, 7, 8, and 9, all reference this act. So it is not saying that that the commission should not act to do anything before that date. It's just saying the operation of Senate Bill 1 should not act to lead to that result. Okay, thank you. And actually, you're about to hear from staff, and they recommend that we do, if we make any changes to the purchase of receivables, COMAR, that we do it through rulemaking. Is that something that? I do think that at some point the commission will. I mean, the statute's going to control if there's an inconsistency between what's in the public utilities article and what's in the COMAR regulations that you've passed. But it's the best practice to make sure that the COMAR regulations are reflective of what is contained in the public utilities article. And as has been mentioned at several points today, there are provisions in COMAR right now that discuss purchase of receivables. And after January 1st, 2025, those purchase of receivable language would not be consistent with what the public utilities article says in that issue. The public utilities article will say that an electricity supplier or natural gas supplier may not sell and a utility may not purchase accounts receivable.
Okay, and you feel that OPC feels we should do that, potentially under an emergency.
Right. So, one of the suggestions that I believe Mr. Krieger from Smith-Mecklen's general counsel made today was that that we not look at this as that we considered making changes to the utility consolidated billing contract. And if you look at the sections that we've talked about today, they do apply to utility consolidated billing. So one potential path that the commission could take is to use emergency powers to suspend the operation of those utility consolidated billing provisions, and instead require suppliers to to engage in dual billing, at least on a temporary basis. That would allow the commission to do a rulemaking in the normal course, which, as I think everybody in this room is aware, can sometimes take upwards of a year or more. And I guess I would agree with the premise that consumers as a whole are probably best served by having the option of having a single bill be issued rather than having having to receive two bills each month and cut two separate checks or set up two auto pays on bills. But I think under the circumstances, the commission is faced with a direction by the General Assembly that includes some pretty significant changes that will take effect as of January 1st, 2025. And now, as Mr. Green mentioned, we need to talk about how we're going to transition from the current system that we have into this new paradigm. I disagree with. I know I disagree with how Mr. Green has suggested that happen. I think that the idea that we would take into account what the suppliers are going to do in the following 4 months, signing customers up on 60-month contracts, as Ms. Peltier just mentioned, is not in the public interest. It will create a situation where utilities are really not going to be in a position to know for sure whether they're complying with the restrictions on SB1 that prevent them from purchasing accounts receivable from suppliers. We also think that in order to fix that, you're going to have to do something almost as complicated as what we're proposing. I think Mr. Green mentioned doing something like the monitoring that the commission has put in place to ensure that suppliers are complying with the restrictions on their ability to sell electricity or natural gas supply to households receiving energy assistance. We don't think that is the best path forward. We think that that the commission acting very efficiently just to end POR as of January 1st, 2025 is in the most efficient way and is in the public interest.
Okay, great, thank you.
Actually, may I just ask one more question? And I had asked a question about just communications and education. Is that something that OPC is working on right now to, I guess, inform, particularly through the choice channels, whether what the law entails as far as customer protections?
We have not taken any action to create any public-facing materials at this point. I think part of that is that the SB1 implementation process is still in flux, and we want to make sure that the information that we're communicating to the public is accurate. It is my hope that when we see the utilities compliance plans that are going to be filed this Friday, and as the work group process that the order contemplates that staff is going to be leading moves forward, that will help us gain some insight into how SB1 will be implemented, and certainly any direction that the Commission could provide will be very, very helpful in allowing OPC to craft accurate public-facing messaging.
Okay, well, thank you for that, Mr. Chair.
Mr. Chairman, I think I do have a question.
All right, go ahead.
Mr. Auslander, so let me just understand clearly the position you're taking. The position you're taking is that in the absence of an explicit statement in the codified section of the law prohibiting us from a retroactive action, that your position is that as a commission, we have the legal authority to regulate on behalf of the interests of the resident of the state of Maryland.
Absolutely.
Okay, that's what I thought. Thank you.
Okay, in your comments, and we've had this discussion earlier today about kind of this rock and a hard place that we're stuck between giving directions to the utilities with sufficient time for them to do what they got to do and to meet this January 1st, 2025 deadline. And you suggest that we take advantage of the emergency provisions under the State Administrative Procedures Act. But if I recollect, there's certain findings we have to make to be able to sort of actuate that provision. And are you comfortable that we're in that kind of situation where we can make that finding? Or, because what I'm concerned about is taking that action and then for those that don't like what we do, giving reasons to actually delay the thing even longer.
Well, I will say that the action that we would ask you to take would need to be effective by the end of this year. So I do think that there's additional time for briefing or fact-finding if the Commission felt that was necessary. When we made this suggestion, we did not yet know that what the utilities' position was, which is consistent with ours. To the extent that the utilities are granted permission to do what they've said that they want to do today, potentially, emergency regulations wouldn't be necessary. But to the extent that they are, what we feel is important is that any necessary legal action that the Commission would need to take to have POR be prohibited for all residential customers as of January 1st, 2025, we would encourage the Commission to utilize those powers.
Okay, thank you. So, staff, you get the last word.
Okay, thank you, Mr. Chair.
They start talking, but let me make sure that everybody can hear you. So.
Okay.
Go ahead.
All right. Good afternoon, Mr. Chair, Commissioners. Lloyd.
Actually,
can't hear him.
Yeah, I need to put it a little closer.
No, actually, I think I needed to turn the mic on here. Can you hear me now?
Yes, better.
Yeah, that's
okay.
That's better.
I think I inadvertently turned it off.
That's fine.
Okay. Good afternoon, Mr. Chair, Commissioners. Lloyd Spivak on behalf of the Commission staff. That is LLOYD, as in David, S as in Sam, P, I, V as in Victor, A, K as in Kite. Okay, I did not prepare a statement here, but I would like to respond to some of the things that I've heard said over the course of this hearing. With regard to the three uncodified sections in SB1, I think you can look at them as being a pretty strong statement on the legislature's part that it didn't want the provisions of SB1 to be applied to existing supply contracts. I think that's kind of how we have to read it, and that was where we were coming from. And
I didn't hear that last statement. Could you repeat that, Lloyd?
okay, I think what you have to, the way you have to view the three uncodified sections 7, 8, and 9 of SB1 is as a fairly strong statement on the part of the Maryland General Assembly that they did not want the provisions of SB1, in particular the ones that are specified in those uncodified sections, to be applied to contracts that existed before January 1, 2025. So, I think we're consistent with the other parties here who have said that. That said, I think Mr. Green overstated his recitation of staff's position, because we certainly did not say that these sections convey an absolute right to retain POR for contracts that existed before January 1st, 2025. As has been alluded to here, the retail supply contracts themselves do not mention POR, and there's very good reason for that, is because a supplier and a customer acting together do not have any legal right to impose an obligation on a third party, i.e. the utility. So they cannot require the utility to purchase the customer's receivables or the supplier's receivables. That had to be done by the commission, and had to be done through its regulations and or orders. And that's precisely what happened. I will say that Mr. Green's history lesson on how this all came about is pretty accurate, however. In response to Ms. Rantala, I think the terming a change that would eliminate POR for residential customers, for all residential customers as of January 1, retroactive, is, again, an inaccurate thing, because it would have something that would apply purely prospectively. It would not be going back and saying that POR that took place in the year before is now reversed. That would be a retroactive treatment of POR. This is not that. Now, with respect to dual billing, that is something that was always done because a lot of customers prefer it that way. Even if you are going to get your supply service from a retail supplier, a lot of people would prefer to do it all with a single bill. And that was one of the selling points for, that suppliers could use. So it was done really, I guess, as a benefit both to customers and suppliers. And I don't think it's probably not the best idea to do something now that would require the elimination of single billing and just require the dual billing. So we are certainly not advocating for that. We do agree that there is a lack of a constitutional issue here. There is no constitutional contract impairment issue here. POR exists purely as an act of the commission. It exists in the commission's regulations. It exists through the commission's orders that establish the current billing agreements. All of that is by the commission. It is not any kind of a contractual right that anybody has. And so to the extent that it needs to be modified in some way, shape, or form, that is not going to be an impairment of an existing contract. I think we seriously doubt that the legislature intended to force the utilities to make large changes to their billing systems. That would be quite expensive and ultimately on the ratepayers' responsibilities for the benefit of, several tens of thousands grandfathered contracts that would gradually disappear. I just can't see them having consciously made a decision to require that. And with that said, I would just like to note that the COMAR requirements for POR, that Section A and the sections that require it, either POR or pro rata billing. Those provisions can be waived by the commissions. Both 2053 and 2059 contain provisions that explicitly authorize the commission to waive those provisions, and the commission might want to consider doing just that until, as of January 1st, until it can craft whatever regulations it would want to replace the existing one. So, and with that, I'm available for questions.
Okay, Commissioner Richard.
Thank you, Mr. Spivak. Just so I understand, staff is advocating that we do what we can to try to get the legislative mandate to end POR by January 1st, but we probably can't, and so therefore we should use a provision to waive the requirement until we can, or I just wanted to...
I think that's a slightly muddled way of putting what maybe and that fault is probably mine. I think what I'm saying here is that, okay, for contracts that are entered into prior or after January 1, 2025, there isn't any question. POR cannot be allowed for them. For the ones for currently existing contracts, the question is whether POR can continue for them. And from the perspective of SB1, it can, because the law explicitly says that its provisions do not apply. However, on a practical level, it seems from what the utilities are saying here that it is not really doable to have one set of rules for pre-January 1, 2025 contracts and one for post-January 1 contracts. And so you, in other words, you have reality clashing with what the legislature's preference seems to have been. And that said, I mean, the only way you can really reconcile them is to do something that eliminates that duality, and that would, I think, be to waive the COMAR provisions pending the pending revisions of COMAR, the completion of rulemaking.
And the rulemaking then would, for all those contracts that were entered into before January 1st, the rulemaking is, if I understand correctly, the recommendation from staff is it would then, upon the successful conclusion of the rulemaking, would end or for all customers.
Well, it would end in a regime that's uniform for all customers. But as I said, I think you would probably need to waive the POR/pro rata requirement for the existing contracts pending the outcome of that rulemaking. You know, unless you believe that the utilities are just kidding and they really could, readily accommodate having a dual system, where some contracts are subject to POR and some are not. So, and I think that's where we end up on this issue.
Okay, and you're taking no stand at this point on dual billing that that would be
well, I think
part of the rulemaking, or would...
Yeah, I think that would be an issue you'd probably want to relegate to the rulemaking and additional fact finding. I mean, there were certainly policy reasons and reasons for requiring it to begin with, which may or may not still be applicable. So, I think you would want to get additional information before taking any action there.
Okay, great. Thank you. Thank you, Chair.
Commissioner Sussman. Actually, you're on mute. So.
I am on mute. Good afternoon, Mr. Spivak.
Good afternoon, Commissioner.
Going to your comments on page 3, and you spoke to this earlier. Taken together, section 7, 8, 9 eliminate POR for contracts entered into after December 31st, 2024, but not for contracts entered into prior to that date. So we've already heard testimony that POR is not mentioned in supply agreements, and the supply agreements were the only agreements discussed in section 7, 8, and 9. There's no reference there to billing services agreements. So why do you think that that the codified language only applies to contracts entered into after the date?
I think it's really the language in the uncodified parts, because I think it is saying that this act is not to be construed to be effective, to be applied to contracts that existed beforehand. I think if you are separating the uncodified and codified parts that broadly, I think you are basically nullifying the uncodified sections. And I don't really think you can do that per se. But
I'm focusing just on the uncodified section.
Right.
And I'm asking you, where in section 7, 8, and 9 is there any reference to the billing services agreement, which is the only agreement where purchase of receivables is addressed? There's no POR in the supply agreements.
Okay. Now, I have to say I'm not particularly familiar with the billing agreements and precisely what they say or their application. That is a good point. This does not specifically mention the billing agreements, but I also think the billing agreements are rather like PR itself, in that they exist because the commission told the utilities and the suppliers to make them exist. It established by its orders, what would go into those contracts. Now they were, I think to the best of my knowledge, and somebody is welcome to correct me on this if they remember differently, but I think all of those things were negotiated as part of the supplier coordination working group, and the billing agreements exist as the commission's ratification or codification of the work of that working group. And therefore, I think the commission has the right to change those agreements, again, based on whatever factual or policy need it sees to do so.
Right, but I'm concerned that we can't change commission policy or regulation if the legislature told us we can't. So I just need clarity on whether the uncodified section 7, 8, and 9, which do not speak to the billing services agreement, only speak to the supply agreement, which, as we've heard, does not mention POR in any way, whether that restricts our ability to address POR.
I do not think it does, because I think both the fact that that is in the commission's regulations, and it doesn't. Neither the commission's regulations nor the billing agreements are addressed in either of these parts of the statute.
Okay, so let's talk about the waiver. Explain to me how we can do that. I mean, do we have to go through a whole rulemaking process in order to get to the waiver, or can the commission do a waiver in an order?
The commission can do a waiver in an order. The rulemaking, that's one of the reasons it's there, but you have to have a sound factual and or legal and policy basis to do so, as is the case for most commission actions.
Well, so I'm sorry I'm interrupting you. The problem is I'm getting like 2 out of 4 words from you, so I'm just trying to. Can we? Would we have the authority to do a waiver and then do a rulemaking? I mean, I guess that could present a problem, because we're then waiving rights that the supplier community would think that they have in anticipation of a rulemaking. So I'm a little concerned about sort of a horse before the cart kind of thing, or the cart in front of the horse.
It's a fair concern, Commissioner, but I think you have to bear in mind that the waiver exists when they exist for use when something in the existing regulations cannot be applied anymore, cannot be fairly applied, or there's some reason that it cannot be put into place. And that's precisely the situation that's developing here. You have, a situation where it appears that the facts are that the utilities will not be able to implement SB1 and continue to do POR for existing contracts.
Right. So if the commission were to find that SB1 actually either authorizes us or requires us to eliminate POR for all supply agreements, we can do a waiver of the provision. What happens to the provision? Can we waive it in perpetuity, or do we then have to go through some process to get rid of it?
I think you can waive it for as long as you need to, but I also think you would be well advised to set in motion the process to replace it. Because, there are, for example, if you look at the telco world, there are standing waivers that were granted by the commission essentially to all new telco entrants other than the ILECs, pretty much as semi-automatically.
Okay.
So, and those waivers have been in existence for 30 plus years and are still there, at least in part. So, a regulatory waiver can be in effect a long time, but that said, here you have, if you do a waiver, you're doing so by virtue of exigent circumstances, and I would think you would want to respond more permanently to those circumstances.
Okay, thank you. That's all I have.
Commissioner Barbie.
Yeah, thank you, Mr. Chairman. Lloyd, so let's go to sections 7, 8, and 9 in the bill. And so basically what your contention is that supply agreements automatically include billing agreements. Is that what you're saying?
No.
I didn't hear what you said.
I said no. I'm not conflating the supply agreements with billing agreements. I'm not.
You know what, Lloyd? I honestly didn't hear anything that you said. So if you could repeat that, please.
I said no. I am not conflating supply agreements with billing agreements, and nor am I saying that 7, 8, and 9 necessarily apply to billing agreements, which are not addressed in SB1. So I think that's probably the closer answer, or the better answer, is that billing agreements are not addressed in SB1. I guess the only conceivable thing that might apply to billing agreements would be the Section 7. It says that a presently existing obligation or contract right may not be impaired in any way by this act. If you look at the contents of the billing agreements as being entirely contract rights, then I guess you could consider Section 7 to apply to them. But again, I don't think the billing agreements really should be viewed that way, because they are basically a memorialization of commission orders. And the commission, just as the commission established them, I think they have the right, for good cause, of course, to change them.
Okay, all right. Well, I really think that this right here in sections 7, 8, and 9, and how we interpret these words is the pivot point of this entire discussion. And so I think that's what we're going to have to grapple with, because the codified provision of the law, to me, really seems pretty explicit. And so I guess we need to really, our homework assignment is to figure out what a supply agreement is, right?
I think a supply agreement is precisely that, an agreement between a retail supplier and a customer that the retail supplier will provide the electricity for that customer uses at whatever the price and other terms may be. So that's a retail supply contract, and that is clearly encompassed by those provisions. But again, those do not encompass POR.
Okay. Thank you, Mr. Chairman.
Okay, so the suggestion's been made by OPC that in order for us to get this process rolling along, we consider utilizing the emergency provisions that are incumbent in the state's rulemaking process. Now, obviously, the utilities got a lot of work they got to do once we decide that process, but staff would, I think, have a lot of work to do if we decide to utilize that process. So do you have a thought about whether or not we should do that? Does this situation rise to the occasion, and anything that we need to think of in order to make you be able to do that?
I think our strong preference would be not to use the emergency rulemaking procedures, just because we are so stretched so thin, and all sorts of things going on. SB1 not.
Mr. Spivak, I can't hear you, and I think your answer is really important for us to hear.
Okay.
This is in your
Let me
hear this.
again try and speak up. I'm sorry that this keeps happening, but I was saying that I think our strong preference would be not to use.
So, Mr. Spivak, maybe you can go to Mr. Auslander's mic, because that might work better.
Okay.
Thank you.
This will probably be the last question.
Might as well hear it.
No, we're trying to take care of it. So. Pull it close and speak loudly.
We'll see what I can do. Is that better, Commissioner?
That's
Okay.
much better.
Okay, so
Okay. All right. Then what I was saying was, I think our strong preference as staff would be not to use the emergency rulemaking procedures, because just because we're stretched so thin with so many other things, and all of this SB1 and other legislative stuff going on, not to mention the regular caseload, and an emergency rulemaking requires a commitment of resources and time over a relatively short period of time that I don't think we have.
Okay. So as a follow-up to that, though, is if we don't use that provision, because I've heard the discussion from at the beginning of this proceeding from the utilities about how much this is going to take, and the fact that it involves IT stuff, which is always problematic in implementing. Can we get the ball rolling, so to speak, on what instructions we want to give to them as to what they need to do going forward, so that we don't blow past January 1, 2025.
I think that may go back to the waivers suggestion that I made, Commissioner. That is, essentially, if you waive those two provisions, then they would, as of January 1, 2025, they would not have to do either POR or pro rata billing, and would have, at that point, you have the time, give them the time necessary to implement whatever you end up choosing to replace them. And at the same time, if you do not, tell them you are no longer required to do utility consolidated billing, which is another thing in COMAR. If you leave that in place, then they would be required to continue doing that at least. So what you would end up with, I think, is utility consolidated billing, but without POR or pro rata division of payments, in which case essentially the utilities would go back to doing what they did prior to the existence of POR, which was basically they took their money off the top and whatever they collected from the customer, and then forwarded on to the supplier or whatever was remained of what the customer paid to pay supplier charges.
Okay, all right. Thank you very much. Anything else that we need to be aware of today? All right, well, with that, we're adjourned, and we'll be in touch.
Thank you, Commissioners.
Yeah.
It's like I'm afraid to look at SB1 to see what else.
Yeah, well,
Yeah.
I love that.
I've only been doing the environmental stuff thing they've done so far, so even that, I think I'd scream if I looked at what else still had to happen.
Mike's on.
Oh, well. We'll see how it goes.
I think the problem is first.
You're not very Hey, one question for you. Like, I was getting worried about that. Yeah, I've heard
Let's try shampoo.
it will be good for our.
Yeah, let the
Sorry. I've actually had a lot of experience in that.
Yeah, of
course. I ran that one.
Oh, did you really?
Oh, yeah. That's no fun.
Yeah.
Okay. No,